Hello everyone and welcome to the channel Contract Simplified. In today's video, we will be studying about confidentiality clause. What is confidentiality clause? Why it is important? And how are you going to draft a confidentiality clause along with certain templates? So let us start. So the first question that comes in our mind is, what is confidentiality clause? It is a set of rules that are setting the limits, the access or places restriction on transaction of the information considered as confidential. It can be unilateral, that is one-sided, or bilateral, that is two-sided. It can be even written or verbal, that is the confidential information could be reduced to writing or it can be even in the verbal mode. So what is confidential information? That will depend on the nature of the business transaction that is being taken place. Even a trade secret can be a confidential information. Now, why do we require this confidential information? It is to avoid the unfair competition, to frame groundwork for legal action, and also to maintain trust in the business deal. That is to ensure that the information stays only between two of the parties or any number of parties that are entering the agreement. Now, let us study how to draft a good and strong confidentiality clause. The first step that has to be done is you have to define what is considered as confidential information. Is there any benchmark for that or any other criteria? And this will not be a uniform definition. That is because it will depend on the nature of the business transaction that is going to take place and also the nature of information that you share between the parties. The second point is explaining about the sharing and storage method of confidentiality information. So you have to specify here how are you going to share the confidential information and where it is going to be stored. This is important because you will be knowing where are they storing so that you can impose certain restrictions on that or you can ask for additional security. For example, if the confidential information is being stored online, then you can ask them for any additional security in their website or any other platform wherein it is being shared, or the user credentials or any additional certificate. So it will depend on the same. Suppose if it is a hard copy that is being stored at a locker, then you can ask for additional security of that locker or to the room where the locker is being placed. The third one is details of the parties who will have access to information. It is not just you are sharing with the company, but you are sharing with the people who are working there. So it is very crucial for you to know who has access to those information. The next one is usage of confidential information. Yes, you have to specify where are you going to use the confidential information that is being shared. If this is not mentioned, then later if they use it for some other purpose, then it will become difficult because you don't have any criteria which is mentioning how they can use the confidential information. By this way, you are restricting the use of the confidential information. The next one is setting off liability, limitations, and exceptions. Here you have to set the liability of the parties. If they are storing at some place, they have to take proactive actions for its security and to what extent they are liable, and also any limitations and also exceptions. For example, if there is a statutory order that is asking for the information that is considered as confidential information, then it becomes a ground for the other party to share the same. So if there is any statutory order, the person cannot tell that, okay, this is confidential information as per the agreement and I will not be able to disclose. That will not be the scenario. So you have to mention what are the exceptions that are to be provided for disclosure of confidential information. The next one is return or destruction of confidential information on contract termination. Many of the contracts miss out on this particular topic, that is, what is the status of confidential information after the contract termination. It becomes very crucial for the company companies to ensure that the confidential information are either returned or destroyed. So if it is any soft copy, then you can ask for destruction, and you can even add a post-termination compliance stating that they would give a written acknowledgement telling that the confidential information has been deleted. The next one is consequence of breach of clause. So you have to specifically mention that is that the ground for termination? So if yes, this has to be specifically mentioned. There is no wrong if it is not specifically mentioned, but contract will carry a great weightage depending on its specifications. So it has to be specifically mentioned that yes, breach of confidential information is a ground for termination. And also you can add another clauses claiming compensation and any other remedies that you would seek for. Help parties to have a good performing contract. The last one is waiver of confidentiality. So here you can mention on what grounds this confidentiality clause can be waived off. This will depend on the nature of the business transaction and the nature of confidential information that is being shared. With the help of this waiver of confidentiality clause or waiver of confidentiality terms, they can have certain relief, and also they can prevent themselves from unnecessarily being harassed by the other company who has disclosed the confidentiality information. So a good confidentiality clause should be containing terms and conditions relating to all of these 8 clauses so that it is more specific and it is more concrete, so that tomorrow if there is anything that is happening related to the breach of confidentiality clause, then your confidentiality clause specifically mentioned in the contract has all the terms and conditions. Now, we have specific agreements like confidentiality clause and non-disclosure agreement. The same thing can be leveraged even in those places also. So this is all about the essential criteria of a confidentiality clause. So this is all about the essential elements that are to be present in a confidentiality clause or in an agreement. Going forward, let us look at certain samples of confidentiality clause. So let me read this out for you. Both the parties to endeavor to take all reasonable measures to keep in confidence the execution, terms and conditions, as well as performance of this agreement and the confidential data and information of any party that other party may know or access during performance of this agreement, hereinafter referred to as confidential information, shall not disclose, make available or assign such confidential information to any third party without prior written consent of the party providing the information. Now here this clause has definition of the confidential information and it is specifying how they can use the confidential information, and the last part speaks about how they can share it with some other party by obtaining written consent of the disclosing party. Example is, the parties to the agreement agree that each shall treat as confidential all information provided by a party to the others regarding such parties' business and operations, including with limitation the investment activities or holdings of the fund. All confidential information provided by a party thereto shall be used by other parties hereto solely for the purpose of rendering services pursuant to this agreement and except as may be required in carrying out the terms of the agreement, shall not be disclosed to any third party without prior consent of such providing party. The foregoing shall not be applicable to any information that is publicly available when provided or which thereafter becomes publicly available then other than in contravention of section 3.2 or which is required to be disclosed by any regulatory authority in the lawful and appropriate exercise of its jurisdiction over the party, any auditor of the parties thereto, by judicial or administrative process, or otherwise by applicable law or regulation. So here you can see that it has defined what is confidential information, how they can use it, and also it specifically mentioned about about waiver of confidential clause and also the limitations and liabilities of the parties related to the confidential information. The next sample is each party shall maintain for 3 years after the termination of this agreement any confidential data recognized as confidential and obtained from the opposite party in the course of this relationship. Nothing herein shall forestall any establishment of every other element of the system from utilizing any data generated hereunder for extraordinary analysis and typical business function. So this clause speaks about the post-termination compliance, wherein it has given a period of 3 years. That is, till 3 years they can keep their confidential information. The next one is the confidentiality disclaimer. If you are not the person to whom this message is addressed, be aware that any use, reproduction, or distribution of this message is strictly prohibited. If you receive this message, this is an error, please contact the sender and immediately delete this email and any attachments. So this one we can find in many of the emails that are specifically sent by banks or other institutions, so that they are adding a confidentiality clause in their email. The next sample we are going to discuss is about post-termination compliance. Upon termination of this agreement or upon request of the party furnishing confidential information, each party shall return the other party's confidential information or destroy the same and certify its destruction in writing. Notwithstanding the foregoing, neither party shall be required to return or destroy confidential information to the extent that such party is required to retain it by law, rule, regulation, or audit requirement, or in order to enjoy the benefits of the agreement. So here you can see that they have specifically mentioned for the return or destruction of the confidentiality information after the termination of the agreement. So this is all about the confidentiality clause that we are going to add in any agreement, and also the confidentiality agreement or the non-disclosure agreement that we do draft. I hope this checklist and the templates were useful. Let me know if you have any questions. You can contact me via WhatsApp in the provided number for any consultation related to the contract or for clarifying any of your doubts. Also, let us meet in the comment section. Let me know how the video was, and also give me suggestions or heads up for any other video that you would like to see in this channel. Also, before going, do not forget to like, share, and subscribe to the channel. Thank you, everyone.